All right. Welcome, everyone, to day 2. Today's presentations will be a mix of live and pre-recorded. This one's live. If you have any questions, we'll open that up at the end of the presentation. Does anyone have any questions before I take off? All right. We'll move on. So this presentation is on other state engineer roles. That will be enforcement and water reuse and recharge and recovery. We'll start off with enforcement. So prior to 2005, there were no direct enforcement authorities by the state engineer. Violations were addressed by criminal complaints filed in civil court, followed by civil litigation. And without civil litigation, there were no penalties for violations. In 2005, sections 23 to 25 through 28 were adopted to provide the state engineer with enforcement powers, define criminal penalties, and associate cost and fees in civil actions. Additionally, Administrative Rule 14 was adopted to detail procedures for enforcement proceedings.
Okay, before you move on,
Sure.
We have a guest with a hand up. Jeff Mickelson, did you have a question? Jeff Mickelson, your hand is up. Do you have a question, or is that inadvertent?
He says no.
I have a question. I'm sorry.
Sure, go ahead.
No, I did not have a question.
Oh, okay. All right then, moving on. So an enforcement action is authorized when a water user is using water without an existing water right or exceeding the conditions of the approval. Examples of exceeding the limiting characteristics of an approval may be unapproved changes in the point of diversion or well location, unapproved changes in place of use, period of use, nature of use, or exceeding the approved quantity of water. An enforcement action is also authorized when a water user fails to comply with a requirement to install or repair head gates and or measuring devices, or fails to comply with an order regarding dam safety or natural stream channel alteration. An enforcement action is not authorized when more than 12 months has passed since the violation ended, or the situation involves private party agreements between water users or internal disputes within water or irrigation companies. An enforcement action is also not authorized when a complaint involves right-of-way or trespass violations, even though it may involve a water-related structure such as a canal or head gate. And to begin the enforcement, the state engineer issues what's called an initial order, and that order will include a description of the violation, a notice of potential penalties, and notice that each day's violation can be treated as a separate violation. Enforcement may result in a fee of up to $5,000 for each knowing violation or $1,000 for each violation that is not knowing. Water user may be required to replace up to 200% of the water taken without authorization. And an assessment of expenses incurred by the state engineer for investigating and stopping the violation could also be part of that final order. Some considerations made before actually imposing a fine or ordering replacement could include the value or quantity of the water taken without authorization, the gravity of the violation, including the economic injury or impact to other water users, whether the person subject to penalties attempted to comply with the order, or the economic benefit to the violator. Goals of the enforcement program include: we encourage public participation in reporting potential illegal use. The public can report potential illegal use by filing a water rights enforcement referral form with our office. That form is located under Applications and Records section of our homepage within miscellaneous forms. So that's how a lot of our enforcement happens, is from neighbors or other residents reporting what they think could potentially be illegal use. Resolution of first-time offenses informally. If violations are considered egregious, they may still be considered for formal enforcement. And any second-time offenses will result in an enforcement action.
Ryan,
Sure.
we've got a question on the chat. It says, what does it mean to replace the water?
Yeah, I figured we'd get that one. I think there's probably a couple ways that the water could be replaced. One, I mean, water obviously has a monetary value depending on where in the state you are, right? So everyone could sit down at a table and come to an agreement on what the monetary value of the water that was taken without authorization is, and compensate based off of that 200%. Another way might be to purchase an existing water right, move it to that location through temporary change application or something of that form to meet that 200% goal for the person that was impaired, or to meet that 200%. There may be other ways. James, do you know of anything else? Any other ways of replacing the 200%? So, I mean, that's a couple instances. There might be more. But yeah, it will involve, sitting down and just basically talking about how that can be compensated for that 200%. But those are a couple of ways. Temporary change application to meet that quantity of water, or monetary compensation based on your location in the state and what the going rate is at the time. Does that answer your question?
Matthew, do you need any further clarification on that? He said that's good, thank you.
Great. All right, so we're going to move on now to groundwater recharge and recovery. This is a picture of Sand Hollow Reservoir down in Washington County. It serves the municipality for St. George and the surrounding area. And basically, this reservoir was constructed atop a high permeability sandstone layer called the Navajo sandstone. I'm sure everyone's probably heard of that. And then in red there around the perimeter of this reservoir, those red wells are considered recovery wells, and they recover the water that is seeping through this high permeability sandstone. And that recovered water is then sent through the municipal system to St. George and the surrounding areas. Other reasons why you might apply for recharge or recovery include storage of excess water in an aquifer for recovery at a later date, or to supplement points of diversion or other aquifers that may not be able to meet demand at the time. Another reason why you might apply for recharge or recovery is to take water from a higher quality water source or recharge into an aquifer to stabilize the water quality or increase the quality of that water in a separate aquifer. An applicant proposing to recharge or recover must apply with separate permits. And an applicant proposing to recharge or recover from an aquifer must have a valid water right or an agreement with a water right holder. A person who holds a recovery permit may only recover the quantity of water within a well or a pump's zone of influence. So that's essentially the area around the well that a pump is capable of capturing the water from. So typically you won't be able to recover 100% of the water that you recharge, right? Because some of it's going to go between the recovery wells. So you can only recover that volume or quantity of water that's within a certain radius of that well or multiple wells. The recharge permit application will include the name of the groundwater basin, a legal description of the proposed recharge project, the source and quantity of water, the water right number, of course, water quality data and permits, hydrologic impact and feasibility study, and a plan of operation. The recovery can be filed alongside the recharge application, but it's not mandatory, and will include a legal description of the recovery wells, the name of the aquifer or source of recovery, the purpose of the project, depth, diameter, screened interval of the wells, and those pump specifications, and a legal description of the land where the water will be used.
Ryan?
Yes.
Question from the chat.
Sure.
Someone said, Mason says, who is the best person at water rights to discuss ASR further?
That would be Jim Reese in our technical department. I'm not even sure what is ASR. What is ASR? Oh, okay.
Mason, do you want to, okay. Is it Jim?
Gotcha. Yeah, it's Jim Reese. Yeah.
Okay. All right, thank you.
Yeah, no problem. Any other questions?
Anybody else got anything right now? Nobody, he was good with that, so thanks.
Okay. So a recharge and recovery permit may require the water user to continually monitor for water quality and potential impacts to the aquifer, monitor the balance between recharge and recovery, and file reports of that data that's collected on water quality and flow rates. And then an annual fee can be assessed or may be assessed to cover the division's cost to review that data and file it in our office. So the next subject will be reuse of wastewater. And that's kind of self-explanatory as to what that is, but we'll kind of go over it briefly. Basically, publicly owned treatment works that treat water supplied under a valid water right can reuse water if the water right is approved for municipal use. The nature of reuse is consistent with the uses approved under that water right, and the public agency receives approval from the Water Quality Board and state engineer. And that application for reuse will include a description of that underlying water right, an evaluation of the diversion, depletion, and return flow requirements, and the proposed quantity of water to be reused. And that was it, short and sweet. Other roles of the state engineer. Any questions before we move on to our next topic?
Anyone have anything for Ryan? You can unmute and ask your question or type it in the chat. Okay, here we've got Matthew Kennedy said, are reuse applications needed for homeowners with gray water systems?
No, I don't believe so. It's only for municipalities.
Okay. says thanks.
Sure.
Anything else, you guys? Anybody got another question? Okay, Ryan, thank you. Appreciate that. You did a great job, and
Yeah, it was good to be with you.
thanks for coming and, live in person.
Yeah.
Not in person, but live, yeah.
Hopefully we'll all get to be in the same room together next year.
Yeah, that would be fun. That would be better. So, but you did great. Thank you so much. We appreciate it.
Yep, have a good one.